Everybody, thank you all so much for coming along. It's 3 years to the week that we held our very first Foil Ireland kind of get-together. It was a meeting here in this room to see whether or not there would be interest in Foil as an organisation to bring along and to gather together the defence litigation firms in Ireland with the view to creating an environment for chat and talk and dissemination of ideas and to meet our colleagues. So 3 years down the road, probably about 2.5 years of being set up and getting ourselves organised, and been good fun over those years. COVID has intervened, obviously. The real benefit, I suppose, to us of COVID was that we've gone online, that the various lectures and talks that we've given have been able to be broadcast nationwide and meant that we can reach out to all our members wherever they are in the country. This is actually my last event for Foil. I'm stepping down as president, which is great, and we'll pass the baton on. I'll talk a little bit more about that later on at the end. But in the 2 years that we've been up and running, we've given our members a total of 1,000 or over 1,900 CPD hours, which is quite a lot. And that only relates to actual events. The opportunity that people have had to dial into online information and detailed talks that have been given in the past, both in Ireland and the UK, brings that number up even more. So in terms of offering services to our members, I think we've done pretty good. It's a pity we haven't had the opportunity to meet more, and I certainly hope that Foil in the future will create the opportunity for more get-togethers and more opportunities to meet and chat and talk. But I do think it's important, and it does ultimately help our ability to work as solicitors and provide our services when you know the people you're dealing with and have met them either socially or at an event like this. This evening, we're going to be chatting about mediation. Mediation as I suppose, a mechanism is something that has become a really significant feature of the litigation market in Ireland, the litigation field. I think it has a particular importance and significance in the insurance litigation market, whereby the opportunity to dispose of cases, settle cases, get cases chatted about in ways that wouldn't otherwise arise. Mediation provides that opportunity, and I think it suits us and suits our clients. So we have assembled who I believe are three of the very best mediators operating in Ireland at the moment, people who I can say from direct experience are effective and who do their job as mediator exceptionally well. I suppose how you judge whether a mediator works exceptionally well is whether or not cases are sorted out and are settled. And hopefully we'll learn from our three, and I'll introduce them now in two ticks, from our three what they feel are the important aspects, attributes and characteristics of good mediators, and particularly, in the insurance litigation field, what we as practitioners can do to enhance the opportunities that mediation presents, and then when we are at mediation, ensure that it will work to best effect. So who we have Helen Kilroy, partner in McCann Fitzgerald. We have Mark Connaughton, Senior Counsel, and we have Sarah Moorhead, Senior Counsel, all of whom, as I say, are amongst the most effective mediators that we have. How I hoped to do the evening wasn't to have just people stand up and give a formal pitch and talk and chat about things, but rather to do it in a very conversational way, where we would ask questions, chat and talk, have differing views perhaps on various subjects, but to have it free and open. If people want to ask questions, obviously it's easier for people who are here to ask questions. Those who are tuning in online, we'd be happy to deal with questions and things later. If you want to text them into us, that'd be just great. So, to start off perhaps, maybe I could ask each of you in turn, perhaps starting with Helen, what you think are the characteristics or the personal traits that makes a good mediator? What would your
That's a
feeling
desperate
be?
question to start with.
Start off with it easy.
I remember somebody saying at a lecture once, one of the best things you can bring to the process is curiosity. So I think as lawyers, our temptation may be to judge and have a view on a case, but I think being curious when you go into each room, you have to be patient. And I'm married to a psychotherapist, so the third thing I always like to think is you're a container. You actually take in a lot, and you then exercise your judgment about how much of it you use. But even just taking it in has a value, So that value of listening to people, letting them be heard. They're very annoyed, and you say, "I hear that, but do you want to do the deal?" So curiosity, just putting the judgment to one side. A lot of listening and containing, and then a bit of judgment about how to use the information. I think if you bring those things and a bit of patience, you're on a good start.
Yeah, I think being a very good listener is extremely important. Mark, what would you think?
Of course, I endorse everything that Helen has said.
Can you hear Mark?
Are you on?
Oh, sorry, I'm not on. I'm just saying that I agree, and I endorse everything that Helen has said about the qualities and characteristics of a good mediator. And I think another thing you have to do, we're all practitioners, is you have to leave your own ego outside the door and get stuck into the problem. It's not you're there to assist and to try and help them resolve it, and that includes dealing with all the problems that arise along the way and dealing with people's anger or frustration, as the case may be. You have to take that on board and get on with it.
Sarah, you'd agree as well, I think. With
I mean, I'm amazed. Anybody who knows me knows I'm not a patient person at all. But I find in mediation that it is the trait that you absolutely have to bring to the party. And it's funny. I think the most important thing as well is you're not under pressure in the same way that a client is, because you've no skin in the game. So you're not sitting there, with your life crumbling in front of you at 5 to 4 because it hasn't got sorted and you have 10 other commitments next week. You're in the process and you try to affect it and you try to get it sorted. But if you don't have skin in the game in the same way. And that is where it's really important, because you don't have to take sides. Now, instinctively, sometimes you can have both sides being really tricky, but instinctively you often find there's just one side. And you have to be very careful as well not to just dislike them or feel, they're just so awkward, no wonder we're here, So you have to step back from that. And you actually frequently find, even though they are very awkward, there's a legitimacy to it. And the other thing that's important as a mediator, you are selling things to each side, in the sense that one of your roles has to be to bring positivity into the room. So, I always say, like, if somebody's very tricky when you go into them, I'm not going to go back to the other side, well, they're really tricky, they're going to be an awful witness, they're going to be terrible. But I do go and say, look, they're very aggrieved for this reason. So you have to try and bring positivity back into both rooms as to where things are going, and just get people to just embrace that. And I have to say the vast bulk of people do, they want to be heard. They do listen,
And in that context, my own experience, I suppose, I would always endorse anyone who's involved in litigation to become an accredited mediator. I think the training in itself is enormously important. But the style of mediation that we have sort of developed here in Ireland is different from the formal CEDAR type rules. I find mediators are that bit more interventionalist, maybe perhaps. Again,
I think we facilitate. I mean, let's be frank. I think I look back at my CEDAR course now, and I think I definitely would fail it. I think we are much more, classic Irish thing. We're collaborative. We tell lots of lies in the rooms. As Helen says, you leave stuff outside the door and you bring stuff in, and you may be a little more poetic or artistic about what you say, or you phrase it differently or anything like that. So I think we're kind of collaborative in settlement, and we also know the people we're dealing with a lot of the time. So, like everything to do with litigation in Ireland, it's there's trust involved a lot of the time, I find.
Mark, would you agree with that?
I completely agree with it. And I would just add that I think this endorses earlier points that both Sarah and Helen have made. You're bringing an energy to the process, and part of that energy is seeing the positives in what people are coming with and making sure, not to mislead people, but making sure to develop that, because you're all the time working towards a solution. And most people in this country that we deal with on a regular basis, they're there because at the very start, when mediation started, a number of years ago, there were a lot of people who were doing it to tick the box. And forgive me for saying this, I found that cases where you had insurance companies involved, there was a lot of box ticking, maybe on both sides, but I certainly noticed that. Now I find generally that people are coming to mediation with a desire to do business. And it's for us to have the energy to bring it on and develop that. And if that means, you know, Sarah put it beautifully, if that means a little bit of, you know, poetic license being taken here and there to keep the show, provided you're not misleading people, to keep the show on the road, I think that's important.
Helen, in terms
Yeah,
of intervening as a mediator, you know, mediators are supposed to be very neutral.
Yeah. It's a timing point. If you go back to when you talk about the CEDAR model, I mean, when we all trained, go into the room, meet, greet, get a signature. What are you hoping for today? Great. Yeah. Go in, meet, greet. Great. Put them in a room together and let them make their statements. And then you do your exploring, then you do your develop to negotiation. And my experience of that going back to when I started doing a lot of mediation, which was 2008, I came back from sabbatical, I had nothing on my desk, got one, got another, and then started doing it, was terrible grandstanding, just a lot of advocating in the plenary, and me not knowing what I was trying to do in the plenary. So I think the thing that I've noticed in bringing clients to mediation is mediators who develop their own way of doing it, which is I like to spend time with people before I ever put them together, if I put them together, and then there's a question about who you put together and what you're trying to achieve. And I would always say to the lawyers, you know what you need to achieve, so you tell me. Like if you think you want a session with the principals or with the expert, tell me, because you know better. So I certainly think we've developed our own style, and it's away from the textbook. I don't know if the textbook training is still on the CEDAR model exactly the same, that you have the plenary very early, but I actually don't do it. But the other slight cultural thing that I think is different, you sometimes notice this with UK colleagues saying, I need them to make a concession on that point in the policy, otherwise we're going nowhere. And I said, look, it doesn't work like that here. I can say to them they're on risk on the point and it'll come out in the bidding, but you can't expect, because culturally we don't do it. In Ireland, we're very slow to say, I'm going to concede my pleading from paragraph 15 on is rubbish. We just don't do it.
No.
So again, there's a learning in that, I suppose. The more you do them, you realise there's a way to manage that. But yeah, I mean, you react to the mood in the room, and you deal with the day depending on the sophistication in the room, or the mood in the room, or the trickiness in the room. You're navigating all the time, you know.
And that comes back to the being sensitive to what the needs and requirements are in the respective rooms, and giving them the opportunity to voice that and to present it.
I mean, do people in the room advocate the plenary at the start of the day?
I was just about to ask that, because I've had a few very bad experiences where people have just become more entrenched.
Exactly.
They're sitting across a room looking at the bad guys who they hate anyway, and it's you have to row back. You're almost 30 love down.
But it's amazing how few people actually want it. You know, I mean, I know we don't, like you don't offer it. I think it's a disaster. I had a very funny illustration recently, even of just leaving two lawyers for half an hour because I had to just do something, and said, well, you're just only reducing the terms to writing. And I came back and World War III had broken out because the words without admission of liability being put on the top. Now, there'd never been a discussion of admission or otherwise of liability during the day, but there was just, so back to your own rooms. But most people actually, you know, even when they really hate each other, don't want to go into the same room and have their say, particularly, you know, even in employment law. Employment law stuff. Is here all right? Am I okay? In employment law stuff. No. It's this thing. Okay. In employment law stuff, definitely. I mean, sometimes it's like family law, they're so entrenched that you just really hope. And the other thing you always have to be careful of is there may be existing, no matter how badly they're all getting on, there may be existing relationships between them that you just have to make sure not to damage any greater than they've been damaged already.
Would that be your experience, Mark, particularly in employment disputes?
Yeah, I would just introduce one small qualification. And this is where another point, and I know you've covered it in your kind of list of things you'd like to deal with, and I know this is very much Helen's, because I've been mediated by Helen on a number of occasions, and a star performer. But pre-engagements before the mediation with parties, I learn an awful lot from that process, and that's just essential for me in any mediation I'm involved in, is to have engagement with the lawyers, engagement with principals if I can at all, on a bilateral basis before the mediation. And you get an answer a reasonably reliable answer from those engagements as to whether a plenary might be of some benefit. If not at the start, then maybe later. And I have conducted mediations, and I have been involved in mediations where there have been plenary sessions where you could cut the atmosphere with a knife, but they have been positive to an overall outcome. But that's not the norm.
Yeah, and you've dealt with it there. It doesn't apply to three of you, but there are certainly many mediators out there who regard the mediation as just being a brief on the day, and they turn up at 9. The importance of preparatory work, of preparatory meetings. I know, Helen, certainly it's something that's high on your list.
Yeah. I mean, I have it in my terms. I say if people would like a meeting, and you kind of go through the phases. When I started mediating, I didn't do private meetings. Then I did them all the time, and then it kind of just settles into where it's needed. Depends on case type. I mean, I see people here who I've done construction mediations with. I mean, most of that work, the prep work, needs to be done by the lawyers and the experts in advance of the day. But as the mediator, you can help just guide people through that process, and then you bring a bit of shape to it. But I think the cases where it's very often invaluable to meet in advance, partnership disputes, shareholder disputes, and I've started doing a bit of family law, so family law disputes, yeah. But Mark is right. You learn a lot, and you don't actually even realise what you've learned until you come away, and it distills, and it certainly helps and speeds you on the day. I give an example of one that I did recently where there was one lay litigant in a piece of litigation who was joined probably because he'd signed a certificate in a construction piece, and he wasn't really going to be a player on the day, but he was potentially a huge impediment. And a half an hour in a Teams call with him, and we were great because I was saying, this is how we'll do the day, and he was saying, I don't have any money, and I'm saying, I think people know that, but you're Section 35 Civil Liability Act, you're a necessary defendant. And then we got to the deal, and then I had to take him through the settlement agreement. So that's an example of adapting, because he's very different. He's not represented or as sophisticated, and you have a different role as the neutral, or as somebody says, the good mediator is partial in favour of both sides. The partiality he needed there was to have his hand held, and he didn't understand the agreement was conditional on both parties paying, because there was an insured and an uninsured. Plaintiff wanted joint and several. Defendants are saying, but it's a workaround, I've done it with you, where everybody signs up, that triggers the payment obligation. If it happens on the due date by both, and he was saying, why can't I get out? I said, it's fine, you will be. Yeah.
I think it's really important. Sarah?
Yeah, preparation is absolutely vital. I mean, you have to, I do a lot of medical negligence and complex things where the people themselves are knowledgeable, but it is very important, particularly if it's a liability, or more particularly causation defences, which primarily they are, that you can engage with the parties. You're dealing with people where there are very significant issues, and they do want you nearly to kind of have a view and say, well, how do you think this is going to run or otherwise? Lay litigants, I'm not advocating being a mediator for lay litigants no more than anybody else, I suspect, on this platform, but one of the important things with lay litigants is explaining the process. And like Helen, I'll make contact with them before the day, and I'll have the chat with them, and I'll explain what the process is to them, and I'll try and kind of make them comfortable with it, and any queries they have. And I do find that generally they become less suspicious of it as a process if you do that. And I do also, I have less of the kind of formal private meetings in advance, because sometimes they can result in a lot of kind of posturing on Teams calls or Zooms, particularly between the parties. But I will invariably ring counsel on both sides or something beforehand and say, look, what's really at issue here? Have you had discussions before? Where do you see my role? What's the sticking point? How do you think it's going to evolve? And exactly your point. Do you think a joint session might be of any benefit or that? So you tic-tac with your colleagues, and you sort of say, look, how do you want to, I'm very much of the view they drive the process too. I'm very happy for them to indicate to me how they want the process driven, provided it's sensible and effective. And generally it is, because people are very used to the process now,
Where I find early meetings particularly helpful, sort of process meetings or just general chats, it minimises the potential for surprises and curveballs on the day.
Like if you want an apology, this is one that comes up all the time,
yeah.
particularly in things like medical negligence and stuff. You know, and they should know about it, but it just becomes a huge issue. And you don't want to be prompting people to, the other thing is you don't want to be prompting people to look for things they haven't asked for. But inevitably, in so many cases, you've got to round 17 and somebody says, and I'm not getting an apology, and you're like, oh great, you know, and then the wording of the apology, and then the falling out over the apology, and all of that. So that's why the prep, in terms of people, if they do want things, you know, please tell us all in advance, and tell us what are the big sticking points for them. You know, sometimes they're deliverable, sometimes they're not, and as we all know, sometimes they don't get sorted out, but they get narrowed down.
I think the other big preparation one that can be a stumbling block on the day is tax. You know, that very often an issue in shareholder disputes, or buyouts, or
employment,
indeed,
particularly.
yeah. But the employment, my experience of the employment lawyers is they just know it inside out, so that's not a problem. But it's when something comes up in the structure of the settlement that people hadn't thought about. Tax can certainly slow it down if people haven't thought in advance.
But certainly surprises and curveballs where suddenly the special damages are increased on the day, or suddenly a sum appears out of the blue, or someone didn't think this was going to be there, can be difficult. I know, Mark, you've been a mediator with me where things like that have happened, and it can cause real challenges and difficulties.
Yeah, I hope you can hear me. I'm not a huge fan of position papers before mediations, but I am a huge fan of engagements with the lawyers. And usually even though Sarah and I are both colleagues, I usually start with the solicitors. And then the solicitors will invariably say to me, well, look, talk to counsel and have a word. But the reason I start with the solicitors is that I like to offer them an early opportunity. Now that we're all using Zoom and all these other remote forms of communication, I find that's where the benefit of those, and to meet with their client for a half an hour or whatever on one of these teams or whatever. And in that, I invariably try to get, having prompted the solicitor in advance, I try to get the definitive list of asks.
Yeah.
So that I can guide them a little bit on expectations. I'm not telling them what to do. They'll make their own minds up, but I can guide them a little bit. And it also helps to avoid that thing of the 11th hour surprise. A colleague of ours used to do it to me in employment cases all the time, Erica Stewart, where he'd come to me at the end of a negotiation, and I'd fair dues to him, and he got it from me sometimes, and he'd come to me in the 11th hour and say, you'll throw in the car. And I go, Ercus, do you know how much the car is worth? It's, you'll throw in the car, you know. But anyway, he knew what he was doing.
In that context of being prepared and knowing each side, perhaps knowing the position of the other in advance as well, is there an optimum time in the life of a dispute for a mediation to take place? Is there a time when it's premature? Is there a time when it's nearly, probably not too late, but premature? Helen, would you have a view on that?
I think the times vary. The cases that you see mediating pre-litigation predominantly, in my experience, are partnership disputes, shareholder disputes, probate disputes, because in every one of those cases, people know what the complaint is, and it's not a case where they really need discovery. If they're a shareholder, they're in the business. If they're partners, they're in business together and they're encountering difficulty. And if it's a probate challenge, it invariably involves family. So there's the sensitivity of not wanting to go public.
And a greater awareness of the cost of litigation early.
Yeah, so those are examples of cases where it can make a lot of sense to do it pre-litigation because it becomes very entrenched. But for sure, there are cases where people would say it has to be pleaded out for me to know the row. Because in each of the shareholder, partnership and probate, you're really talking about divorce invariably. So it tends to be fiscal. The outcome is fiscal. I'm kind of interested in what you say on the preparation piece. I am very slow to ask the wants in advance because, funny, sometimes when I've done it, it has set expectations that then can be hard to unravel. But it's kind of, I'm interested, is that predominantly in employment cases that you would do that, or is that across the board?
No, because I predominantly do employment cases, mediations in employment cases, I would say it's more in employment cases. But I do it a lot in other cases, and what I'll then do is I might engage in a little bit of early testing in relation to things, because I do think if I perceive something is likely to be a difficulty, I just feel the earlier confront is the wrong verb to use, but the earlier I challenge that,
Yeah.
then at least we know, well, look, this is something they're sticking hard on. And when I start to have conversations with the representatives on the other side, I can say, look, guys, we're unlikely to get somewhere unless we can do something under that heading. And it helps in that way. But you're absolutely right. I mean, if you ask people to just give you a sort of a list of the asks, you're potentially setting up. So it comes.
You're doing it with the lawyers, and you're using a lot of judgment. So
Exactly,
I see the
exactly,
sense of it.
yeah.
Going back to just one example of when is it too early? There is a decision of is it Butler J or is it Toomey? Anyway, it's a case recently where a party was saying they couldn't go to mediation, they didn't have enough information. But I did a mediation once, and it was trying to remember how you describe the dispute, but anyway, it was a commercial dispute between parties. They weren't related, and it was a massive claim. I think it was 100 million, and came on the day, and they were offered back to back, so it didn't settle. The plaintiff didn't seem that bothered, and 4 years later they came back to me, and it mediated and it settled. And what happened in the intervening, they had probably 3 interlocutories up to the Court of Appeal, rows about things. And what the plaintiff said to me when he came back, he said, I couldn't afford to settle 4 years ago because I was trying to refinance my business. I was trying to get into a different region globally. And once I got those things bedded down, he said, if they'd offered me this money 4 years ago, it actually wouldn't have been enough. So that's the bit about being curious. You know, you should, because you never know. But certainly as an advisor, the client needs to understand the claim against them or the claim they're prosecuting, and that the other side understand it. So how you achieve that, I hear what you say, Mark, on position papers. I call them case summaries. And in family partnership and shareholder disputes, I ask people not to give me an exchanged document because it entrenches. But in lots of cases that you do, people will say to you, I'll give you a 5-page summary where the commercial court pleadings are 5 volumes. That can be very helpful.
And certainly in the world of litigation, insurance litigation, by and large the parties will know the respective positions of the other side. But again, it's to avoid curveballs, it's to avoid the surprise. And I think if there are pleadings, they help. But again, that early engagement, the chats and the talks, the procedural chats, and that can feed also into, and again I think it's particularly helpful in insurance litigation disputes, the role of experts, where engagement between experts in advance can be very important. We've had 1 or 2 instances, Sarah, where having the experts engage in advance, and not necessarily agreeing with each other, but ensuring that people know what's been said and what's been
Not
said.
agreeing with each other.
Recollect, sorry. Yeah, I mean, much of what I do is litigation, and it's last minute that they come. So their cases are listed for hearing. And one of my big issues is to try to get them to stop being absurd and not exchange reports with each other, particularly if the case is going to be on in 10 days' time or 2 weeks' time. And they're all sending me the stuff, and I'm operating Chinese walls in my head in relation to a case that's going to be on in a couple of weeks. And I'm like, you know, you have to be big boys and girls here and call it as to what you're going to actually rely on. Now, there are other times when I see reports and I decide, do you know, probably it's not helpful that they exchange. We're better to keep our powder dry, but you've also obviously to be very careful then as to what you're telling each side, you know, and that's important anyway. I mean, that's something, you know, when we all go into the room and you're all experienced at this, you know, what we bring out of the room. And, you know, I always say, particularly if it's anything sensitive, you know, if you want to talk to me on your own, if you want to, you know, particularly in some of the more sensitive medical negligence, you know, if you've had a really bad time you'd like to, or particularly female to female sometimes happens, they do want to come in and just have a chat separately, all those things. But yeah, I think things like shareholder agreements, definitely, where people are going to spend a lot of money and they know there's an out. Employment law, where once the injunction gets up and running, you know, I always say it's going to end, the relationship's going to end. It's only how expensively it's going to end, you know. In other parts of litigation, there's a reluctance really to engage until the full picture is out there. And the full picture does normally include, you know, getting discovery and getting examinations completed. And And then in a lot of litigation, the experts, but like in the non-personal injuries litigation, as you say, Michael, it should be possible to get the experts to delineate the issues between them. And I always think it's useful sometimes to have a meeting in the room just with the experts and say, well, you know, what's that issue between you, you know, and what can we iron out, or what can we reconcile between you? And that does work.
That would be your experience as well, Helen. Getting the experts into rooms away from the lawyers can be very helpful at times.
Yeah, I suppose the two areas where I come across experts the most are construction negligence claims and then shareholder disputes. So in one instance, it's articulating what is the negligence and what damages it caused and who's guilty of it. So the whole Scott schedule piece. And in the other, it's very value driven. The construction ones can be more difficult. A lot of that conferral happens before they come, and sometimes there'll be a final twirl on the day. But again, depending on who you're dealing with, you can experience those expert sessions as very advocating. So if it's happening on the day of mediation, I go in, I tee it up, but I leave. I don't sit with them because they actually do business quicker speaking to each other. So I have a kind of a rule of thumb. I leave the accountants. I say, when you've finished working out your EBITDA and your multipliers and your range, call me.
Yeah, it's always nice to leave accountants alone.
Yeah, but you go back in and you get the briefing. So at least as the mediator, you hear what they've said to each other. And if it's framed differently in the rooms, you then know who's framed it differently. But absolutely, the expert conferral is it's important. And I think it was Michel Calapetis, who's a very renowned mediator, QC in the UK, and he does allegedly 100 a year. He's a busy man, but talking about how do you break the impasse with experts, and he said, really, it's actually just about sharing in the room risk. So I don't actually get too stressed if the experts don't get there. It's great when they do, because it speeds it up, narrows the issues, but it's about understanding that if Peter's expert or Sinead's expert prevails, what does that mean for your room? But getting the experts to do as much as they can before the day is great. It's a very frustrating day if everyone's sitting around saying, well, I can't actually form a view until my engineer comes back in and tells me. And I would, you know, there are some insurers who you experience are claims handlers, and they won't move until they hear what the experts have said.
Yeah.
So that doing it in advance is very helpful. Speeds up the day.
And in terms of the claims handler or the claims official, having the claims handler and claims official there when an insurer is involved is important. That be your experience, Helen?
Got to have the decision maker in the room. So
have to have the decision
query,
maker
are
in the
they
room.
the decision maker? And sometimes, you know, obviously when you're dealing either with institutions, state institutions, insurance companies, PLCs, the person in the room tends to have a delegated authority. So they've come with a level of authority. But again, it can be very frustrating if there's a sense it's somebody in London and at 6 o'clock we can't get them. And sorry, as practitioners, we're often dealing with that because we have a claims handler who won't travel. So, you know, but my experience on the bigger construction cases, when the claims handler comes, they more often settle than not.
Far greater chance of settling.
Yeah.
Again, Mark, your experience?
I completely agree.
Yeah.
And my only difficulty sometimes is that it's all written up correctly, it's all very clear, and then it transpires that the person doesn't have the required authority and you can refer back. And most people are actually very, and I would describe it as generous on the other side whenever difficulties like that are presented. But it does mean keeping a mediation on kind of tenterhooks where you're nearly there, you have in principle worked something out, but you can't deliver it and can't bring it home because somebody has to go back and get an authority. And I'm not just talking about state entities where things have to go up the line to that wonderful government department where you only get hired if you eat your own children. So I'm talking about, you know, generally, and there is, you know, I have been not burnt, but I have been surprised in the past whenever I've been confronted with that difficulty.
Absolutely.
But anyway.
And Sarah as well, we've had situations.
I mean, claims official, the claims person
Is absolutely vital, because what I do is I'm going into the room essentially to say how the plaintiff is going to present. And again, on the positives, I'm not going to say, you know, they're going to be a terrible witness or that this and this, but you need to be, in order to, as the claims person, in order to assess the risk of the litigation going on, you need to be there to get the feel of how somebody presents or how the case is going to run. So that's absolutely vital. There is nothing more frustrating than, and in fairness, I distinguish very much from the State Claims Agency, who just massively engage in mediation, and all claims handlers, if they're not on Teams or Zoom, they're there in person, and dealing with some government departments, and inevitably, whoever's in the room is only out to have their tea for the day, and you immediately say, well, you know, are we going to be able to, and it drives plaintiffs bonkers. And so in state mediations, I've now said, there must be a decision maker available on the day. It is fruitless, and it actually incenses plaintiffs that there might be as Mark says, a deal ready to be done and nobody can call it. And you could have, I've had experiences recently of 10 people in a room, and when you go in to say who'll sign off on this, they tell you that none of them will sign off on it because none of them has the authority to do it,
But having the claims official present to appreciate the risk, to understand what's been said, the opportunity to communicate is never as good unless it's first person. It's a given.
I think it's very hard for the solicitor to go off and ring up and say, Sarah Moorhead or Helen Kilroy, Mark Compton, say, this lady would be great in the witness box, and there's an element, people are going to say at the end of the line, she would say that, wouldn't she? Whereas if you're engaging with them in the room, it's different. They're going to ask you questions, they're going to raise things with you, they're going to say, look, are we wasting our time? Are we not wasting our time? And I often say to people, even if it looks very unrealistic at the beginning, I'm never pessimistic at the beginning of a mediation. I might be more optimistic at the beginning of some than others. And like everything we do in life, some days are easy and you earn your money easily, and some days are bloody hard and they don't even end at the end of the day. You're constantly ringing for weeks afterwards. But it swings and roundabouts. But I always say to people, particularly people who are not used to it, just because the ask is, massive, or anything, don't worry. That's just exploring the process. Let's just keep going. Let's go a few rounds and let's just talk and let people have their say. And, you do come to a point, and like everything in life, it massively accelerates at about 4:45 in the afternoon or 8 o'clock in the evening,
Yeah, but I think the claims handler being there, the piece that you developed, which we haven't talked about, and you mentioned it earlier, it's trust. So that bit about ringing the lay litigant and having the conversation and getting them comfortable with the process, it's exactly the same for the claims handler. Like if they're in the room, they're judging the temperature, they're hearing the entirety of the conversation when the mediator isn't in the room. And I think as solicitors, it's an impossible task to actually convey that temperature to your claims handler if they're not there. It really is. And, things get lost in translation. But also as the mediator, like sometimes that claims handler is quite happy to settle at this number. And you get the read of them in a way. The solicitor might be saying, we can't possibly do that. And they're going to do that, and that's fine. But to your point, Sarah, the bid that comes in at $1 million when the reserve is 250 and the claims handler hears that remotely, as opposed to you saying, it's okay, we're managing it, we're just going through it. Just let it breathe, Yeah,
I recall a very good example you and I had, Helen, where I was with the plaintiff in a building damage case, and you suggested bringing the plaintiffs in with you to meet the claims handler without any lawyers involved at all, because the claims handler was hearing a story and a version woefully different than you had heard in our room. And you felt, having met the plaintiffs, that if the claims handler had the opportunity to hear them firsthand, that they were, as all Michael Corrigan's clients are, honourable, decent, nice, lovely people. But the claims handler met them, sat down with them, they chatted and talked and went through their problems and difficulties and how they arose. And I think the claims handler challenged them in relation to many aspects, and they had answers and they explained it. So the prejudices that had been, or the barriers that had been put in place, were eroded, and the opportunity to reach a settlement, simply because the claims handler was there, was able to have direct experience of what was involved. Now, it involved a leap of trust. You don't normally hand your clients over to be questioned, but it worked in that instance, and it was very important.
Yeah, and I'm thinking of that claims handler, English-based, always travels, always comes to the mediation, never does it without coming. And in many construction cases, the claim, very significant claim value, if I remember, but the works hadn't been done. So there's always a skepticism on the insurer side. This is just for them to get a wedge. It goes into the accounts, and these works will never be done. But this was actually a chemical treatment plant, and there was subsidence issues, and there was no question that the work had to be done. It was a kind of a health and safety issue. But you're right, Michael. Things as they had been translated, and it's not a criticism of the lawyers,
No,
but
no, it's just
how
how
things had been said into the room actually just didn't do justice to the claim. And the claims handler said, I've got a limit on my, let's say she had 5 units with her and she needed 7 to settle. And she said, I can't go back unless I get some answers. And after she met them, she said, okay, now I know why you tell me I have a problem. But I've seen it and I can bring that back. And she said to them, I will not be able to settle with you today, but I will take it away. And it resolved after that. But it was because she was there and she experienced it.
And it worked both ways. They came back to us in the room and said, we met with the claims handler. She was empathetic, she listened, she took on board all we had to say. And they believed they were being treated fairly, as opposed to the adversarial, nasty lawyers, putting up a front. So it broke down barriers. And I think that's probably one of the greatest benefits of mediation. It has the potential to break down barriers and to get to your zone where things can be done. I think employment law, or employment disputes, particularly, Mark, we see that. I certainly have seen that, where that degree of emotion, skepticism, anger, barriers, the barriers have been put in place. Lawyers can frequently align themselves too much and not provide the necessary objectivity. But mediation breaks that down.
Yeah, I think actually I feel a bit of a fraud being here with the other two, because employment cases are actually a good deal easier to mediate, because as Sarah pointed out, she didn't use this exact phrase, but they tend to be quite binary. It's not about the maintenance or the continuation of a relationship by and large. It's going to involve a severance of a relationship, and your job there is to keep a balance between the parties and mediate the dispute, rather than telling people you're bunched here, you have a rotten case, and all that sort of thing. But I find that in other mediations that I do, and I wouldn't have anything nearly like the experience that Helen has or Sarah has in doing other disputes, but of the relatively small number of other disputes that I do, I will instantly know, pretty much from the early engagements, whether this is a process as opposed to meeting on a given day to try and resolve the thing. I'm involved in one. I actually did a call out on the way up here, where it's an entrenched dispute involving an estate, family estate, and there are significant property that's going to have to be sold, etc., etc., etc. And we've all agreed we're in a process, and it's about managing that process and dealing with things along the way, and deploying experts in a particular way. And sometimes, going back to a point that was discussed earlier when we were making contributions on experts, look, just like in everything else, there are lawyers and there are lawyers, and there are experts and there are experts, and some experts are just wonderful to work with, because they're going to collaborate and reduce the issues. And it's mainly after that about whether the clients want to deploy it from a tactical perspective, whether they don't want the experts agreeing too much before they get the negotiation to a certain stage. But using experts in a particular way, and I have engaged in mediations where I have got, with the permission of the clients, I've had engagements with the experts where they talk among themselves, and I agree with Helen, you stay out of the room, you let the experts at it, but where the experts have access to me as mediator. So I'm able to go back to their principals, to their respective clients, and say, yes, that point was shared with me in confidence, and we're holding back, you're holding back on that, that's understandable. I now need to have an understanding from you as to what you might do under that, and that keeps everybody right. The experts get on with dealing what they can deal with, they agree as much as they can, and I then get a knowledge of the areas where the little pieces will fall into place on the outstanding matters. When you're trying to draw up a Scotch hedger or something equivalent to it, that kind of thing. And there may be an element even of negotiation in that. Helen made this point in another respect earlier about, there are things that turn into numbers, but they have to get there.
And again, Sarah, in many of the large personal injury claims that we've had, often excluding the experts it can be helpful, because we know they are advocates for whatever side they're on, and they just get in the way.
Yeah, they don't.
This, yeah, they don't. Yeah, like in some of the larger personal injuries claims, which Kevin Cross used to always say, why do you need a mediator? You all know each other well. You can go down to the forecourts and just settle it. And I'm more and more interested when the more and more they're coming in. They're not always necessarily big value claims, but they're tricky claims. I mean, particularly, tricky plaintiffs, people who, to use the great horror phrase, want their day in court. And there's the try to explore the mechanism of why they want their day in court, and the classic line at the beginning of it, money will never be enough for me.
It's not about the money.
It's not about the money. It's never about the money till it's about the money. And I've rarely found a plaintiff still who wants the apology and at the end of the day gets the money but doesn't get the apology, who holds out. So there's a lot of managing of that, and there's a lot of managing of relationships. I'm always fascinated when I go into a room to see not just the litigant but who's with them and where the power balance lies in relation to that. And I have to say, I have seen some extraordinary examples of what is a kind of a phrase we use now of coercive control to some extent in the room between parties, and very much the person not being in control of their own process, and it's very tricky, and it's also very tricky and delicate because you can't really say to them, look, do you want to talk to me on your own? Although I always say that to people, if you'd like to talk to me on your own, or if you feel comfortable, talk to me on your own. But in a lot of cases, I found they're not always driven by themselves, they're driven by other parties. And you have to get that party on board as well, because you get to a particular point and then they say, we're going for a walk, and you always have to give people as much time as they want. We're going for a walk or we're going for a coffee or something. And then just the dynamic as to whether, if you feel you're making progress, when they come back, has that been undone or otherwise? So, looking at the personal dynamics, the body language, what's said, who's speaking for whom. I mean, you would be amazed still how many husbands speak for their wives. It is just extraordinary. And, oh no, she won't want that. And she won't want this. And, you have to be really careful not to say, do you not think she could speak for herself? But you have to engage him, and you're right. And then you see, if people are going through a tough time, they've lived through it too. So they're vicariously, wanting you to feel their pain as well as the pain of the person involved,
Absolutely. Our hour is nearly up. There was one particular topic I wanted to raise in the context of mediations. Would the experience of any of you have ever been that those who have agreed to participate are doing so not with the view to ultimately settling, but almost abusing the process with the view to not really caring whether it sorts out or doesn't, participate, learn as much as they can, and benefit to the detriment of the other side? Has that been a feature of your experience, or is it something that we...
I think since the Act has come in, I call it, I was speaking on the Act maybe 2 years after it came in, and somebody said, what are the things you notice? And I call it the "Are you free on Friday?" phone call, or "Are you free on Friday week?" Where people, seems to me, are ticking a box because they've got to mediate before they issue the summons, or, as we now know is the practice, they won't get a date unless they can tell the judge they've attempted to mediate. So I tend to find I don't mediate those cases because I'm not free on Friday week. Because they're dashing it through, they don't care less
Just
who
for
the
the sake of it.
Well, they don't care who the mediator is, and happily you're sometimes doing something else, but they're not really cases you're interested in doing, because you just get the tea leaves from the request that it's, and that's very different to, are you free on Friday because we've an injunction on Tuesday,
Yeah.
and we've had an adjournment. That's great, happy days, you're interested in that.
And a more
I'd
cynical...
have to say, though, in my experience, sometimes what I've noticed is a reticence from lawyers, not from clients. We couldn't possibly make that point because that'll be very useful when we're at trial and we're cross-examining. And you kind of, now I can't say that's been a recent experience, but it certainly was something I used to experience going back 10 years. But in the round, you definitely have people coming and they don't have enough money to settle. So you'd say to yourself, did they really want to settle because they couldn't believe that's the value of the claim? But I have to say, my experience of colleagues is one of the most refreshing parts of the work, and colleagues from all over the country, you know, and people doing a very good job by their clients, and some do it better than others, but I have to say it's not really experience I have in the room, but certainly some of the requests you get, you just say, I'm not bothering with that.
The times often one hears as a justification for a reluctance to participate, oh, we don't want to reveal our hand, or if we reveal our hand, it'll be taken advantage of by that fecker who I didn't like before, or who's done me before. So there's a concern, certainly, that there are people out there that will abuse it. But if that is not your experience, Sarah, would you have a different view?
Well, firstly, I think
Most people are genuinely interested in it. I'm always very careful as to what I'm bringing back. So take, for example, something we're all familiar with, the statute of limitations. You know, the odd time you get the person like really wanting you to go back and ask the plaintiff all about their data knowledge and when did they discover they really had the injury and things like that. And I always go, whoa, hold on a minute, you know. The papers are the papers and everything is there and the documents are documents, but mediation is not a process of interrogation. It is a process of being upfront if you're prepared to be and to clear what's going back into the room. But the odd time, and it's very odd these days, you get the sense that somebody, they are meaningfully engaged in the mediation process, but if it doesn't work, they'd like to know a lot more by the end of it for the purposes of the litigation. Your antenna goes up fairly quickly when that happens, and I very firmly say, you know, I'm not going back to the plaintiff to ask that question, or I'm not going to the defendant to ask that, let them, you know. But most people now, you know, they're in litigation, they're supposed to be, now Irish people are great still at trying to hide everything and the SI 391, and you know there's 7 attendances that haven't been disclosed on both sides because they've talked to the doctors and they've talked to their experts and, you know, they've all had transcripts of conversations. But like, because we are all involved, we know that. So I'll frequently say, you know, what did the doctor really say to you, you know? Or, you know, or would you want to send me the attendance in confidence, you know? So, and then we steer around what we're going to go back to the other side with. But and you know, also, the other thing is, like, colleagues want you to help them. That's the other thing that happens a lot. You know, apart from their diary exigencies and their worry about everything else, they really want you to help them, particularly if they've got a tricky plaintiff or a tricky claims handler or a tricky expert. They want your input. And I do always say, I'll give you as much of my opinion as you want or as little of my opinion as you want. It's your process. But the amount of people who say to you, like, look, will you tell them what you think? Will you tell them what you think? I said, look, if they ask, I'll tell them what I think. But if they don't, that's, you know, and you can't, and you also say to the lawyers, you can't abdicate responsibility. At the end of the day, it's your call. That's what you're paid for, not what we're paid for. But I actually think most people are really, I think the tick boxing has gone away a lot. Like, even with people who were suspicious at the beginning of it, they'll come back to you after the first one, particularly from people down the country, and say, God, that was really meaningful. I do that process again, which I always think is nice when they say it.
Do you find that, Mark, that abdication of responsibility where the legal team for a plaintiff or defendant wants you to deliver the bad news and wants you to be the person to be saying the case isn't as good as it is as opposed to them?
Occasionally you'll get that, but I have a way of dealing with that, and it's not very sophisticated, but it does involve having a good, you know, conversation with the lawyers and then involving their client and having a conversation, you know, a side conversation before the mediation ever starts about these things. But I again come back to the point I made earlier. There are some mediation requests that come into me and I know by the look of it, I'm now engaging in a process rather than in a mediation day, and it'll have to be conditioned towards a resolution, and hopefully we get there eventually, or we at least reduce the number of issues. But I will endorse what both Helen and Sarah have already said. I don't generally find, A, that people are coming to mediations just to suss somebody else out, and B, I generally find that most parties now are engaging in mediation because they really want to try and get a resolution to it. So I'm reasonably positive about the whole thing.
And does that feed into the issue of compulsion? You know, that parties should.
Totally against the compulsion thing.
Yeah,
If it isn't voluntary, it doesn't. You know, look, people have got to be coming to it because they want to come to mediation. I'm not sure. I know there's provision for it under the personal injury side, but how often does it happen? You know, that parties are directed to mediation. Almost never, I would have
Have
thought.
you had that, Helen?
I had one experience recently, just as you were saying it reminded me. So, case coming to trial, they were maybe at mediation 6 months in advance. Plaintiff suing a defendant who joined a third party, so plaintiff looking to recover sums due. And defendant really, when I went into the room, bit of a chat process, whatever, and what are you hoping for today? Nothing. I want my day in court. Literally. And it's kind of like the classic, and you say, does anybody actually say that? And that's more or less what happened. We were, despite the lawyers and everybody working hard, but that's very exceptional.
The shortest mediation ever,
Yeah, well,
nearly.
close.
Oh, you see, I rarely have that. I had one recently, and I just knew from the beginning of the day that it was an injunction teacher. I knew from the beginning of the day, and like her lawyers were practically crying. It was so eminently settleable and sorted out. And it didn't matter what happened, exactly that. I want my day in court. We went through the process, we came at it at a different angle. We did this, we did that, we discussed this, we did that. And I actually finally had to say to them all, guys, like, just wake up and smell the coffee. This ain't going to mediate. This lady wants her day in court, and it doesn't matter what you do, you're wasting your time. So they've gone off, they've got a reserved judgment on something at the moment, so on we move.
I sometimes say it through gritted teeth, but even when I'm confronted with something like that, I will say, look, I'm your mediator. I appreciate your withdrawing at this stage, but you have the right and entitlement. And unfortunately, it happens that they do come back sometimes.
Yeah. They do come back.
Yeah. Our hour is nearly up. Just one small final thing, I suppose, to raise, and I think it would be true of certainly mediations I've had with each of you. The mediation that doesn't settle on the day, where the parties have got close and there are differences there. The importance, I think, of a really good mediator, following up, continuing to cajole, continuing to get the parties to engage. I think, again, I would regard it as being a very important part of a mediator's role. I think each of you would be, I can think of examples with each of you where that is exactly what has happened. You would all regard that as, I presume, very important and as an integral part of your job.
Yeah, and very often what is happening on the day is somebody in the room can't say yes to what they're hearing because it's not exactly what they want. So the plaintiff who isn't offered exactly what they want, or the claims handler who hasn't brought enough money, but everyone can smell the deal. So there's two variants on it. One is where the plaintiff gets the offer they don't want, and I know a lot of people don't like this, but I've done it a lot where they can't say yes, they just can't. But if you give them 48 hours, they will.
Yeah.
And you say to the defendant room, leave the offer with them for 48 hours. So that's an interesting one where they're very close. And the other one is where the defendant hasn't come with enough money, whether they're a claims handler or not. I had one very recently, and the lawyer was very shocked when the client told him, as the defendant, what his authority was. And he had expected the authority would be 4 times that. And we very quickly agreed after lunch we needed to pause so they could go away and fix it. But the last version is the version where we just haven't quite got there on the day.
Yeah.
And that's the one where, I think it's always great as a mediator to say, I'll be in touch next week. And the solicitor thinks about it and says, Jesus, if only I could get my guy or my girl to do it. And you say, if I could get somebody to do this, would it help? And that's the sense checking point that Mark talks about. If you can get it done in advance, great. But sometimes you end up doing it afterwards. And with effort, thinking of the one we had with you, Michael, that the
Yeah,
where
it's as good an example of where it really works.
yeah, where we got stuck and we had 4 defendants and we just kept knocking at it and it took us 2 months, but
Yeah, we got there.
yeah.
And Sarah, we had one.
Yeah.
I can think of one,
We've
a
a
big
one saga.
Yeah.
And the other thing is, if you think it's going to go pear-shaped just because, people are not prepared or something emerges on the day, I'm always inclined to try and get them to agree. And most times this happens, we won't call it abandoned, we'll call it as you say, stalled or halted or anything. Just in the interests of kind of keeping good relations between them all and people not kind of storming out. So I had one the other day where, you know, they were kind of talking apples and oranges, but they both had to go off and do their homework. And rather than saying, this is ridiculous and whatever, I said to them both, look, you know, you can both blame the other that you came with different expectations and not enough information for the other person. So you were never going to be on the same pitch in terms of today. But does that mean we abandon? And actually, when I said to them, but they said, no. And in fact, I got a letter from them today saying, we're doing the rest of our investigations and we'll be back after that. And that's, again, it's good to try and keep that process going with people and for them to feel they can re-engage if at all possible.
Endorse all of that,
Yeah.
and sometimes I might write 2 confidential letters, one to one side, one to the other, just on a bipartite basis, and not so much tell them what to do, but highlight some of the key points that have been raised and things that they might look at again, but not telling them what to do,
Yeah.
but just things that they might look at and consider in the overall mix. Coming back to Sarah's point, or I know she was giving it as an illustration, but you know, if somebody's making a very, you don't have to agree with it, but making a very forceful claim that the statute is there, just saying, look, that is an issue that's there, they believe very strongly in it, you'll give advice to your own client, but these are the things I want you to consider in the mix, that's all.
Yeah, and I think following that up, certainly has been my experience, works to great effect. And those mediators who just perceive their role as being a brief on the day, and the shutters come down and off they go, and the potential for further dialogue is lost. So I suppose that brings us to the end of our little chat about mediation. I would so like to thank the 3 of you for coming along and chatting to us. I know it was called Sharing War Stories was the topic. I kind of thought that was woefully inappropriate in the context of mediation, but it's kind of a bit appropriate as well.
It's a great incentive to come when somebody doesn't ask you to write a paper.
Well, I thought we were getting papers, but we did I not tell you?
No.
It's not on the letter.
No, it's not on the letter.
No, absolutely not. So thank you all so much. I really appreciate you for sharing your knowledge and your experience with us. So thank you. As I said at the very beginning, this is my very last function or as president of Foyle. I'm stepping down now after the 2 years that I've been president. So I just want to thank everybody that I've engaged with and interacted with. I think there's a real role for Foyle in Ireland amongst the insurance litigation world. I hope that the foundations that we've begun to put in place, I think if COVID hadn't come along, we'd have done a lot more. I think there's a lot more to be done. I like the idea of stepping down on the day that Boris Johnson was forced to step down, whereas I'm walking away gracefully into the sunset.
Dems, was it?
So thank you all. So thank you all very much for all that you've done for me. I really appreciate it, and I've enjoyed my time. And I'll still be coming along to the various events, sitting down, looking at people panicked as things are being organised and being done. So thank you all very much, and thank you all for this evening. We're going to have some drinks and things if people would like to hang around, some drinks and canopies. But those tuning in remotely, I'm afraid, can't share with you. But I hope the opportunity for us all to meet again in person will arise again and again and again. So thank you all so much. Thanks, Anne.
I wonder if I might just detain you from your glasses for just a moment or two, because I just wanted to take the opportunity to say thank you to Michael for his tenure. He keeps talking about 2 years as president. Actually, it's been 3 years, but clearly the time flew past and he only thought it was 2 years. But he's been absolutely magnificent as the first president of Foyle Ireland, and been really, really grateful. I really genuinely do not think that Foyle Ireland would be where it is today if it wasn't for the sort of vision that Michael had to develop this new idea into your market. So I think another round of applause, please, for Michael. He also keeps saying this is the last event that he'll be at, but I think we'll probably plan something to mark the handover to the next president of Foyle Ireland, which is a gentleman at the back there, Noel Devons from Kennedy's, who's kindly stepped forward and agreed to take on the role. Big shoes to fill there, Noel, but every confidence that you'll do a brilliant job. So Congratulations, but I'm sure we'll have a proper formal handover around about November time, and hopefully Michael will be there, and as will all of you and everybody watching at home. So thank you very much for that. Thank you.